The president cannot, by any shred or shadow of authority, seek to injunct Parliament from exercising our lawful duty and responsibility as the House responsible for lawmaking. Neither the courts can injunct Parliament not to perform our duties as Parliament. The courts, under Article 2 of the Constitution, can declare a nullity or a void to the extent that Parliament have passed a law which is inconsistent with the Constitution. As far as me I'm concerned, even with my understanding of the law, there is nothing before the courts, because a bill remains a bill. Until it's assented to by the president, it is not law. Therefore, as far as I'm concerned, there is nothing before the court that somebody will seek to use that to injunct us from performing our lawful duties. That's why the Constitution in Article 106, if those of you who are familiar with it, it reads, the power of Parliament to make laws shall be exercised in bills passed by Parliament. In bills passed by Parliament. So Parliament has passed Human Sexuality Bill, assented to by the President, Article 106. It has not been assented to. So there is no law yet. So whoever is seeking to question a law must show us which law he is referring to. But Article 106 imposes an obligation on President Nana Nkommo Wo Ho as the executive head of the Republic of Ghana. It says that when Parliament passes a bill, Parliament shall remit the bill to the President for assent. That is what this BDO2 letter is seeking to do. And you have to read it well. He says that they are at Peduasi Lodge on 14th March when the clerk attempted to serve them Human Sexual Rights and Family Values Bill 2024 at Jubilee House. And that the office is aware of pending applications. So he himself is a lawyer, pending applications. A pending application does not operate as an injunction anyway, pending application. But in any case, what authority has he writing to the clerk to do what? But we find the words he has used very unacceptable. He says the Attorney General have informed their office 18 March 2024 that the President has been duly served with both applications and had advised the President not to take any step in relation to the bill. It is not for the Attorney General to advise the President not to take any step. The Constitution dictates what the President should do. Assent to it or refer it back to Parliament with an explanation or to the Council of State. It didn't say he should refer it to the Attorney General. Yes, Article 88 gives him a mandate. The Constitution is very clear. So what we want to do, and as part of the matters I raised before Parliament, we must now know when the Parliament remit the bill to the President, and we will count 7 days. If 7 days have lapsed and he has not assented to, and he has not written back to Parliament, nor to the Council of State, we will hold the President responsible for a constitutional breach, and he should know the legal, lawful, constitutional consequences of his action. So this is why we've called to address you that it's a matter of grave constitutional threat to our democracy and to the proper and effective functioning of the constitutional structures created by the framers of the 1992 Constitution, which envisioned separation of powers, not the predominance of any organ over the other, not the predominance of Nana Nkommo Wo Ho over every other organ of state. He is wrong in law, he is wrong constitutionally. The clerk should ignore this communication.